Welcome back to another explainer. Today, we're unpacking an absolutely fascinating collision between state judicial power and academic logic. We are going to look at a unique legal case where the boundaries of law, philosophy, and complexity science intersect in a way you have likely never seen before. It's essentially a story about how institutions define truth and how one single scholar attempted to deconstruct a criminal charge using mathematics and epistemology. Okay, let's dive into this. It sounds like a bizarre paradox, right? Can your level of education actually be used against you as evidence of a crime? Well, this is the exact, incredibly real situation faced by a PhD student named Dr. Chen Jingyuan. He found himself facing criminal charges, specifically for picking quarrels and provoking trouble by allegedly spreading rumors online. But here's the catch: the prosecution didn't really have direct evidence of his intent. Instead, they used his PhD as the primary evidence to prove he had a malicious state of mind. They essentially argued, look, you're highly educated, therefore you must be guilty. Wild, right? To understand exactly how this unfolded, here's our roadmap for the explainer. 1. The core legal dispute. 2. The philosophical defense. 3. The scientific defense. 4. The logical defense. And 5. The ultimate legal clash. It's a true battle of linear judicial logic versus nonlinear academic complexity. Starting right off with Section 1, the core legal dispute. So the foundation of this charge rests on a legal concept called MingZhi, which translates to actual knowledge or clear awareness. In Chinese criminal law, to be guilty of intentionally spreading a rumor, the prosecution has to prove MingZhi. They literally need concrete evidence of your subjective intent. They have to prove that you actually subjectively knew the information was false before you spread it. It absolutely cannot just be presumed based on a guess, or in this case, someone's identity or background. Now, let's trace the exact steps the prosecution took. This is their chain of logic. Step 1, the defendant has a PhD. Step 2, therefore, he should be able to distinguish right from wrong. Step 3, therefore, he actually knows the information he saved and forwarded is false. And step 4, therefore, he is guilty of malicious intent. Do you see the huge leap there? They completely substituted actual, tangible evidence of his state of mind with a blanket assumption based purely on his high level of education. They essentially replaced "he actually knows" with "well, he ought to know because he's smart." Now, what's really interesting about this slide is that we are looking at a massive clash of paradigms. On one side, we have judicial linear logic, this very straightforward, rigid assumption that A inevitably leads to B. On the other side, we have academic nonlinear complexity, which is Dr. Chen's multi-layered defense. You see, instead of just saying, hey, I didn't do it, Dr. Chen built a defense using the very academic frameworks he studied. He didn't just fight the facts, he fought the entire epistemological and scientific foundation of the prosecution's assumptions. Which brings us to Section 2, the philosophical defense. To build this first pillar of his defense, Dr. Chen turned to epistemology, the study of knowledge itself. He argued that human cognition is inherently limited. Maintaining a deeply skeptical attitude toward all knowledge, he relied on Plato's cave, that classic idea that we often only see the shadows of truth, not the truth itself, and Gödel's incompleteness theorem, a mathematical principle proving that no complex logical system can prove all truths within itself. He used these heavy-hitting concepts to argue that absolute truth in complex social or political matters is ultimately unknowable. Therefore, subjective, absolute knowing of a rumor is impossible for a scholar whose default state is skepticism. He framed this as cognitive humility. Look, if absolute truth is unprovable, then MingZhi, that absolute legal knowledge of falsity required for a criminal conviction, simply cannot exist in his mind. He argued that he was just collecting diverse viewpoints for research, not maliciously spreading known lies. This philosophical stance directly blocks the legal presumption that a highly educated person automatically knows a subjective statement is false. It's a brilliant move that completely short-circuits the prosecution's very first assumption. Let's move to and see how this builds in Section 3, the scientific defense. Having tackled the subjective element, he next deconstructed the objective requirement of the crime, and he did this using complexity science. To prove he physically couldn't cause a systemic social collapse, he brought in scale-free networks to show that social networks are just naturally chaotic. He used Cohen's threshold to mathematically prove that a tiny marginal node in a network cannot trigger a system-wide shift. And he used avalanche dynamics to show that without a massive central hub, a viral cascade or an avalanche of social chaos is scientifically impossible. So how did all this high-level math actually apply to his reality? Well, his account had fewer than 100 followers. He had almost zero interactions. In network theory terms, he was placed deep, deep in the long tail of the network. His actions acted only as background noise. He proved mathematically that his isolated actions couldn't possibly create a butterfly effect that would result in severe public disorder. He even brought in this equation, R0 is significantly less than 1. Now, in epidemiology and information spread, an average branching ratio, or R0, of less than 1 means the spread of information is in a deep subcritical zone. It guarantees extinction. It means the information will die out. It's absolutely not going to go viral. Therefore, the severe social chaos objectively required for the crime was, quite literally, a mathematical impossibility. Moving right along to Section 4, the logical defense. To dismantle the normativity and fairness of the prosecution's argument, he used a classic logical method called Reductio ad absurdum. Simply put, this means disproving an argument by showing that following its logic inevitably leads to a completely ridiculous or absurd conclusion. He used this technique to masterfully expose the selective enforcement and the inherent contradictions in the charges against him. So the crucial point is this chilling conclusion he laid out. If collecting controversial materials for research is a crime, well then all scholars are criminals. He pointed out that if his academic habit of saving and discussing diverse, even controversial viewpoints is treated as a criminal act of picking quarrels, then the entire academic community is guilty. By taking their logic to its natural extreme, he showed that using a scholar's research habits as proof of a crime threatens all academic freedom. And finally, we arrive at Section 5, the ultimate legal clash. Interestingly, multiple advanced large language models, AIs programmed to analyze legal texts entirely objectively, evaluated this exact case, and their consensus was completely unanimous. The prosecution's reliance on the defendant's PhD was found to be a fundamental legal error. It was a direct violation of the presumption of innocence. It was a clear case of subjective imputation, basically just guessing intent, replacing actual evidence. It made a totally flawed leap from should know to actually knows. And objectively speaking, there was a complete absence of proof that any societal chaos actually occurred. And this brilliantly illustrates the core tragedy of this entire case. On one side, we have scientific rationality, a brilliant, mathematically sound, logically rigorous defense meticulously built by a scholar. On the other side, judicial power, an unyielding institutional system that entirely bypassed evidence in favor of an assumption based on a PhD. It's a stark, almost unbelievable disconnect between analytical truth and administrative authority. Which leaves us with a final, rather provocative thought to chew on. Where exactly is the boundary between academic freedom and legal liability? When does intellectual curiosity cross over into the crosshairs of state power? And honestly, if a PhD can be used as evidence of malicious intent, what does that mean for the pursuit of knowledge itself? Thank you so much for joining me on this explainer, and I hope it gave you a really clear, structured understanding of what is truly a complex and fascinating case.